Many people have asked the question, why was the identity of Lucy Letby's victims, the parents of those victims, and also the identity of some of Lucy Letby's work colleagues withheld from the public? In this video we take a look at a recently released piece from Professor Tim Crook, which takes a look behind the scenes of Lucy Letby's trial and highlights the importance of open justice. Open Justice. Lessons from the Lucy Letby case by Professor Tim Crook. The reporting restrictions imposed by judges in the criminal justice process and the trial of convicted serial killer Lucy Letby have been unprecedented and controversial. There has been no case in British legal history, or indeed in the history of English-speaking common law legal jurisdictions such as Australia, New Zealand, Canada and the USA, where the identities of 7 murder victims and 10 attempted murder victims have been censored. There were further reporting restrictions giving lifelong anonymity to 9 of the adult prosecution witnesses, namely doctors and nurses who worked alongside Lucy Letby on the neonatal unit. The reporting ban on identifying the murder victims was retrospective. When Miss Letby first appeared before Warrington magistrates in November 2020, there were 8 murder charges and the names of the infant children were widely published and reported. A month later, the prosecution and police made an application to Mrs. Justice Steyn that publicity for the parents would undermine the quality of and their willingness to give evidence as witnesses. The judge agreed to this in January 2021. The restrictions were imposed as a result of legislation passed by Parliament in 1999, the Youth Justice and Criminal Evidence Act, specifically Section 45, power to restrict reporting of criminal proceedings involving persons under 18, and Section 46, power to restrict reports about certain adult witnesses in criminal proceedings. Section number 2, Censorship. The degree of secrecy and censorship even extended to the return of the guilty verdicts by the jury. It seems that the trial judge Mr. Justice Goss imposed an order under Section 4.2 of the 1981 Contempt of Court Act, preventing the media from reporting any of the verdicts until all had been returned by the jury, or it was clear they were unable to return verdicts on some of the charges, which was the case in respect of the attempted murders. This means there are several days when Lucy Letby had been found guilty of murder, but neither the professional media, nor indeed anyone else, was permitted to report this to the general public. It could be argued that the nature of this censorship was and is a form of discrimination, because if you, as a member of the public or a journalist, could physically gain access to any of the proceedings, you'd have been able to hear the names and full identities of everyone mentioned in court. You would have heard the return of guilty verdicts before they were all reported. As it was, the public gallery space in the courtroom was very limited, and there would have been the added problem of actually finding the location of the murder trial. The public listing of the trial even omitted the name of the defendant. The Chartered Institute of Journalists has therefore asked the 2 judges making the reporting restrictions to release their rulings, on the basis that organisations like the Institute will need to understand the judge's reasoning, as this will be crucial in the teaching of media law in future. A consortium of media publishers including The Guardian, the BBC and the Daily Mail did challenge them, but there was no further appeal to the Court of Appeal Criminal Division, which is possible under Section 159 of the Criminal Justice Act 1988. These media organisations had argued that the restrictions made it virtually impossible to report the trial properly, and that by reducing the description of victims and witnesses, this risked turning the trial into an alphabet soup. However, Mrs. Justice Steyn ruled, the quality of evidence given by each of these witnesses is likely to be diminished by reason of fear or distress on the part of the witness in connection with being identified. Section number 3. Criticism. The restrictions have been strongly criticised by human rights lawyer Geoffrey Robertson KC and by the former Lord Chancellor and Secretary of State for Justice Sir Robert Buckland KC. The censorship continues, with a fair proportion of the parents of the victims giving extensive multimedia interviews, providing great detail on their feelings and views about Letby, and the NHS executives of the NHS Trust which employed her. This extends to the intense public interest and political debate about what kind of public inquiry should be held. Will the public inquiry continue the censorship? To what extent will the head of the inquiry be bound by the judicial decisions of Mrs Justice Steyn and Mr Justice Goss? Writing in the Daily Telegraph, Geoffrey Robertson KC said, quote, "Open justice is the most sacred of all British legal traditions, yet in this case it was abandoned because witnesses and victims said they felt discomfort about being identified." He argued their claim to privacy was allowed to outweigh the public right to see justice done. But this is not a question of balancing these two irreconcilable values. Open justice should always prevail, except in cases of national security or where victims would be seriously harmed. He warned, the very fact that these secrecy applications succeeded will doubtless encourage more attempts to suppress information about what goes on in court. It was unsatisfactory that in this case the application was made by the prosecution. The agent of a state that should be proud of its open justice tradition. Sir Robert Buckland said, quote, "The overwhelming general presumption is that the names of witnesses and defendants are matters of public record, available for use by the media. Public knowledge of and confidence in the administration of justice is enhanced by comprehensive media reporting." Okay, so what are some of my own thoughts regarding this article in particular? Now, a lot of people asked me this question during the trial. Why is each child known as a letter? Why are you referring to child A, child B, child C, child D, etc.? And basically that's because there were reporting restrictions on the victims, on the children, and also the parents, as well as some of the doctors and nurses who worked alongside Lucy Letby during her time at the Countess of Chester Hospital. There were very stringent, very strict reporting restrictions. However, having attended Lucy Letby's trial in person and been there in Manchester Crown Court, what struck me was that, okay, we've got these strict media restrictions. The parents' names, the children's names are not mentioned in any publication, yet they're being spoken about, they're being read out, they're being discussed in full during the court process. So the full names of the children, the full names of the parents, the full names of every doctor and nurse involved in this trial was read out in full. So yes, you have on one hand these very strict media restrictions, but on the other hand, any Joe Blogs, any stranger can just wander in off the street, pull up a chair and listen to all of this information firsthand. So in my mind, it's quite counterproductive. The other issue with this is that by having this sort of air of secrecy surrounding this case, it massively feeds the conspiracy theorists, because I'm not kidding when I say this. I have seen forum threads where they've been trying to track down nurses in this trial. Look here, look at this rota. Look at the rota. Look, who's that nurse? Look, that one there. That nurse. There's no name. Let's find out who that is. Let's find out who that person is. That's the person who's responsible. I'm not kidding. That is genuinely what you hear online. Doctors and nurses who have given evidence and have chosen to remain anonymous and have been granted that are then being hunted down online by conspiracy theorists. If you don't believe me, I'll provide proof to you. So by having this, as I say, veil of secrecy surrounding the case, it massively feeds into this conspiracy. Well, there's something deeper going on here. This is a cover-up. Why is that person's name not mentioned? It just feeds that conspiracy narrative. I also found it interesting in that article there that not once in British legal history have we had a trial or a case where victims' names have been granted anonymity. Not just in Britain, but in other English-speaking countries. Australia, United States, Canada, New Zealand. Not once in any of those countries has the victims' names not been read out or mentioned in court or granted some kind of anonymity. So let me know in the comments section down below, are you for open reporting, open justice in this country? Or do you side more, I guess, with the prosecution and the families of these children? Do you understand why they may want anonymity for their children? Bearing in mind we're talking about very, very young children here, an extremely tragic case. Do you side more with open justice, more transparency, or do you side more with protecting the identity of not only the children, but the parents who are involved in this case? Let me know your thoughts down in the comment section below. As always, many thanks for joining me for this video. If you are new to the channel, don't forget to hit the like button and subscribe down below for future content regarding this case. And very shortly you'll be able to see the Lucy Letby playlist, which has all of the videos that I've created regarding the trial and the case of Lucy Letby, all in one convenient folder. Many thanks for joining me for this video. I look forward to seeing you all again for the next one. Take care. Cheers.